Go. All right, so we are recording. We are live. It is noon Central Time on I guess it's Wednesday already, September 25th. And today, everyone, we're going to talk about why estate planning. Um, and then why now, I guess. But you've all been on a lot of these calls with us so far. A lot of you started this in August with attending a Social Security workshop, and in the last month we've covered a lot. Right, we've covered Medicare, long-term care, taxes. Now we're getting into estate planning, um, and it's one of those things that, as certified financial planners, can we give legal advice? No. Can we practice law? No. Can we explain how a trust works, though? You bet. Can we explain why you might want to think about a trust? You bet. Right, that kind of thing. And so that's why we talk about estate planning. We're not attorneys. We're not practicing law. We're not trying to be attorneys, but we are trying to say, hey, when you talk to your attorney or when you talk to an attorney, ask about X, whatever X might be. And we have some resources where we can even give you something that's called a specimen document that is an example of something that an attorney would need to draft for you. But it is watermarked with the word example on it. So the reason I'm saying all that is we've got to be super clear, just in case you were wondering, we have to be super clear that we're not attorneys, we're not practicing law. Okay. And here it is in writing. Okay. Um, but let's start off with just a quick why you need to consider estate planning, even if you're not quote unquote rich. Um, we've all been around the block a bunch of times. Ken and I, and the rest of our team here, we see all kinds of different scenarios happen. And the fact is, nobody knows what's going to happen the rest of today. Nobody's going to know what's going to happen tomorrow, the next week, month, year, the rest of your life. You do not know what's going to happen. You've got ideas about what you want to have happen or what you hope are going to happen, but you don't know. And if you think you do, you've got some challenges in front of you that are coming because it's not going to go the way you expected. It just isn't. Like Ken was saying as we were getting going today, we didn't come in thinking that our email server was going to be down. I mean, that wasn't part of the plan. Ken, I'm going to share some personal information you just shared with me. We didn't assume Ken Jr. was going to bite another kid at school today, right? I mean, we just, what's happening now, right? Who knows? I have an 8-year-old and 11-year-old. Who knows what's going to be going on when I get home tonight?
Let the record show allegedly bit.
Oh, there you go. There you go. Okay. Okay. Yeah. Yeah.
Allegedly. We need
Yeah.
evidence.
Yeah. Allegedly bit. But that's the thing is we don't know what's going to happen. And so from a financial planning standpoint, what we get into is, when you do pass away, what would you like to have happen? You're going to have stuff left behind. How do you want it disposed of? And I know that sounds really clinical when I say it like that, but that's the question, right? You have some retirement funds left over. Who do you want to get them? How do you want them to get them? You have a house left over. You've got a savings account. You've got a car. You've got the stuff in your house, right? How do you want that stuff to go to the people you care about? Or, and this is always a plan too, and we hear this from time to time, if you don't care about that, that's okay. It just means that someone's going to have, a much more difficult time picking up the pieces and getting them all distributed the way the state says they're supposed to be distributed. So, as we know, when you pass away, nobody knows how. Everybody's going to die at some point. We just don't know how. And is it going to be early? Is it going to be late? Is it going to be quick? Is it going to be slow? And when I say slow, is it I've got Alzheimer's and it's going to take 3 to 5 years, but I'm going to be at a point where I can't make decisions for myself? Or is it like one of my godfather who passed away in a motorcycle accident and had such a bad head injury that even though he died relatively quickly, he could not make decisions for himself while he was lying in that hospital bed in the last few weeks of his life. Uh, think about that for a second. What position does that put your spouse in, your kids, the people who care about you? One of the things we talk about with everyone is make sure you've got a medical directive, make sure you've got powers of attorney drafted up as part of your estate plan. The reason why is if you are in a position at some point where you're laying in a hospital bed and you have what's called an IRA, an individual retirement account of any kind, well, it's the I stands for individual. That means you own the account. Your spouse does not. If your spouse needs to get $20,000 out of your IRA to pay property taxes, your spouse can't. They literally cannot do it. So when we think about, how we're going to pass away and the manner, the manner of that passing, we've got to do some advanced preparation. Ken, do you want to talk a little bit about some of the, how we get to the point where we start talking about this advanced preparation?
Yeah, and it's really just that. It's talking about it. It is sharing stories of your past experiences, maybe aunts, uncles, parents, grandparents, what you witness, but also just openly discussing what your wants and wishes ultimately are. As you can imagine, over the decade plus that I've been doing this, the decades Matt and our other partner Jason have been doing this, we've had a fair amount of these conversations. I'm thinking about one in particular where they inherited a home. And that sounds nice. That sounds great. But this particular individual was distraught. Yes, they had this asset, but they had no idea about what the wishes were for this house. Did they expect, did the parents that gave it to them, did they expect that child to move in? Did they expect them to rent it? Did they want them to just sell it and take the proceeds and use it for their retirement or vacations? Their part of the estate plan is, yes, moving the assets from one person to another, but the other part of it is making it easier on those you care about and communicating those ideas, what your wants and wishes. And at the end of the day, depending on the structures you have, you can guarantee your wishes are followed or just at least that they're communicated. But literally minutes, hours of work now on the front end will make it easier for everyone. And it just starts with the conversation.
Right. Right. So what happens when you die what's called intestate, without a will, without an estate plan? Well, for those of you in Texas, for those of you in California, we've got some people from Nevada on today's call. We have some people from Arizona as well. Your state has a plan for you. It absolutely does. Your state will then step in and say, okay, based on our probate system, this is how the assets get disposed of. And they will also publish your estate a minimum of 3 times. And the reason they do that is because they need to make sure that if there's legitimate creditors out there, people you owed money to, they need to know that you passed away and they need an opportunity to step forward to recover those assets from your estate. It's a legitimate reason why they do it. The challenge, of course, is when they publish it, everybody else pops out of the woodwork too. Now, most of the time people talk about, oh, well, this guy tried to scam me. And certainly there's shady individuals who will pop out of the woodwork. I mean, absolutely there are. But there's also legitimate businesses that'll pop out of the woodwork as well. Auctioneers, realtors, sometimes auto dealers will start trying to reach out to you to purchase a car, right? Stuff like that. I mean, there's a host of others as well. So all of a sudden, all this stuff starts just hitting whoever the people are that are trying to wrap up the estate. And to Ken's point that he just made, they might not really know what you wanted to do because maybe y'all never talked about it. That's a problem, right? That's a problem. So it's not just a problem from the emotional standpoint, it's also a problem from the mechanics of it. What do I have to do now? I've got to follow the rules of this probate judge. I got to go get a power of attorney so I can access the retirement account. I've got to go do this. I've got to go do this. I've got to go do this. You can see where that's going, right? You just added a full-time job for that person, that maybe wasn't expecting it at all. Okay, we've talked medical directive a little bit. This is something you absolutely have to have in place. And going back to my godfather again, the medical directive is super important, to be able to go in and pay bills and things like that, especially if there's the power of attorney attached to it. But where it's critically important is care. Now, Ken works with a lot of hospitals, and whenever we start talking about this with some of our hospitals, the nurses especially get all fired up. And the reason they get fired up is because they're the ones who bear the brunt of this. So think about this for a second while I paint the picture for you. So my Uncle Ken is laying in a hospital bed. He has no medical directive. He has one son who's not religious at all, one son who's very religious. As you can imagine, they have very different ideas about what should happen. And who's the person who's caught in the middle? It's not Ken. He doesn't even know what's going on. It's the hospital staff, because the hospital staff, they have to follow state rules for care. They do not have a choice. The only way they can deviate from the state rules is if there is a legally bound medical directive in place that says, nope, this person did not want any life sustaining whatever to occur if they were completely incapacitated. Okay, the hospital has a copy of that. They can now follow that person's wishes. It doesn't work that way if they don't have the legally bound directive saying this is what needs to happen. Okay, so this is super important to make sure this is done. Ken, do you want to talk a little bit about paying bills and transacting business and paying taxes, maybe? Like how long do taxes
Yeah.
have, that kind of thing?
So Matt mentioned it, but it's really worth repeating is if you are incapacitated, you do not have access, uh, your spouse, partner, children do not have access to accounts like an IRA. IRA stands for individual retirement account. So if they are needing to dip into any of those assets to pay bills, to pay for regular property taxes, whatever it may be, they don't have the means to get into that through items like a power of attorney or springing power of attorney, where they only have access to these accounts in the instance of incapacitation. That can be really powerful to have. But just because you are in a bed receiving treatment doesn't mean your water bill, your power bill, your taxes, all those different things, there are bills that still ultimately need to be paid. Other fun fact, not fun fact, full disclosure, is when settling the estate, depending on what assets you ultimately have, to Matt, what Matt was alluding to, is if the IRS is due to some, if the IRS, if there's a tax bill due to somebody's passing, the IRS needs payment within 9 months of that person's passing, not 9 months after the estate is settled, 9 months of the passing. And Matt might be able to rattle off some fun facts of how long some of these estates have taken to get settled, but they can be years. If you or a loved one owns some ranches or properties, if you have 100 acres out there, how quickly do those sell within 9 months when all those property taxes, when not only the property taxes, but the estate taxes are due? A lot of those deals take multiple years for them to settle. So how are we going to do that? Making sure that there's a level of liquidity and access to the funds in all circumstances is part of the estate plan that is oft overlooked.
Yeah, and folks, that's Ken, you make a great point. If you do have significant assets that do take time to dispose of, maybe an office building, maybe, a business, right? I mean, there's a lot of stuff there. It's usually a really good idea to have some kind of permanent insurance, because that provides instant liquidity to help, grease the skids, if you will, of having those transactions take place, right? To Ken's point, if I got to pay property taxes and I'm thinking realistically, it's going to take me 18 to 24 months to get the right offer. Well, if I have the money completely separate, ready to go to at least pay bills, taxes, upkeep, all that kind of stuff, and maybe that was funded by a life insurance policy, fantastic, right? Fantastic, because it means the money's there and I can now sell at the right time and at the right price. I'm not forced to fire sale because property taxes are coming up and I got no cash to pay the property taxes. I got to sell now, or I got to go take out a mortgage on the property or whatever, right? So there's a lot to that Ken's talking about. There's a lot you can do from a planning standpoint. The other thing, and this goes back to Ken's directive about that house for that one client of ours, you may have been thinking very hard about this stuff, but if you didn't talk about it, if they don't know, if it's not in writing, um, and this doesn't just happen when you pass away, this sometimes happens when you just get seriously ill. Ken, do you want to talk about your client that had a long-term care policy, but somehow nobody knew about it?
Yeah, this was actually my first instance of doing this. Put a plan in place with one of my very first clients, and everything was going well. Fast forward about 4 years, and there was an incident that he was incapacitated. The problem was, is I didn't know about it for about 8 months. I had been calling, sending emails, regular check-ins, just never heard back. And then eventually I got a call from his son and let me know the news. And long story short, I personally got frustrated and upset because there was a policy directly in place that and they had done transactions and things that were detrimental to the estate, because there were these tools in place that would have provided, I believe it was $6,000 a month at the time, to fully take care of these expenses, but the liquidity wasn't there. So they had to sell off pieces that were intended to go to the family and loved ones. But because they didn't know me, because they didn't know that there are these mechanisms in place, they made the best decisions that they thought with the information they had. Since then, I've learned the hard lesson. For each of our clients, we insist that we meet your kids just at a minimum, that they know our face and our name, and to call us if and when these things happen, so that it never repeats itself. But yeah, they need to know where these documents are, what plans are in place, because that's why we did it, to use them.
Yeah, you got to communicate, right? And the legal documents and all that. And it's not saying you've got to tell them every last detail, but it's just, hey, here's where we store this stuff, right? To Ken's point, here's the names of our important advisors, our attorney, our CPA, our property casualty agent, our financial planner, maybe even the mortgage broker, right? I mean, who knows, right? There's a lot there. But if people don't know where to turn, then they're not going to be able to access funds right away. Like in Ken's case, there was money in a long-term care policy that could have been used, but nobody knew it was there. So now they're not able to access funds. And that then means assets go to the wrong people. So here we've got Barry White. Um, it's one of those endless celebrity issues you hear about where someone passes away and maybe a beneficiary designation wasn't correct. Now the wrong person is getting the money. We helped someone retire from HEB. For those of you out of Texas who don't know HEB, it's a huge grocery store chain here in Texas and also in northern Mexico. And this guy had worked at HEB for almost 35, 40 years. He was getting ready to retire. We were helping him with his 401k and what to do with it. And on the documentation on his 401k, it listed this woman named Jane as his beneficiary in case something happened to him with the 401k would go to her. Ken, was he married to Jane?
He was not.
No, he was married to someone else. Jane was his girlfriend back in the day when he first signed up. He just never thought to update it. He didn't know he should have to update it. If something would have happened, Jane would have got the funds, and she has no legal obligation whatsoever to send that money to his spouse, his kids, the charities he loved. None whatsoever. So you've got to make sure this stuff is in place, not just so people know where the documents are, know how the bills can get paid and stuff like that, but you've also got to make sure everything's current so that when you do pass away, the money goes to the right people. One of the biggest things we see, 15 years goes by, your kids grow up, they start having their family, and somebody dies, and then they're like, oh, it would have been nice if we could have had some money go to the grandkids. If you would have updated your documents, you could do that, right? It doesn't even need to be an issue. Okay. Taxes can eat away at your estate. I would say the biggest thing that a lot of people look at today is they say, oh, well, there's an estate tax. Well, there is, and it's about $12 million is the exemption limit per person, which means there's a $24 million exemption per couple. So basically anything below that number, there's no federal estate tax. But keep in mind, that's part of the 2016 Tax Cut and Job Act. Depending on how the election goes in a few weeks, that may expire at the end of next year. And if and when it does, you're going to see that exemption pretty much get cut in half. Now, here's where this can be important. Let's say you own a small business and a house, and you have some retirement accounts, and so does your wife, and so does your husband. And you can see where we're going with this, right? It's not as hard as it may sound for some couples, certainly not every couple, but for some couples to start having an estate tax issue. We're working with a group right now where we're helping them in their small business with what's called a buy-sell arrangement. Hey, the Supreme Court just ruled that if your company owns your buy-sell life insurance policies, that is now considered a taxable part of the estate. That alone could suddenly create estate tax issues for you. So when you're thinking about taxes, a lot of people hear that 12 million number and they're like, whatever. But then when you start adding all the pieces up, hey, if it drops back down to where it was pre-2016, you might be having some issues that you need to deal with.
Matt, if I can elaborate just a little bit more
Yeah.
for taxes. One thing to also be thinking about is which assets are we giving to whom? Let's say you do have a charity or church close to your heart. We've seen some clients, well, I'll just leave whatever is left over my checking savings account, but my kids are going to receive X percentage of my IRA. Well, an IRA to a person is a fully taxable event when distributions happen. With the most recent rules, it has to be fully liquidated within 10 years. So if you gift or inherit $500,000, it's either $50,000 a year for 10 years, $500,000 this year, whatever that 500,000 grew to in year 10, but all of that's going to be taxable those years. Where if you left those same dollars to a charity, because it is going to be effectively a donation, that charity receives all $500,000. So where if you left 500,000 in a brokerage investment and you left that to the charity, there's no tax benefit or savings to them. But if you left that 500,000 to an individual, they get a step up in basis, and now that $500,000 is basically tax-free. So depending on which assets you're giving to whom can really determine the taxability of those assets and that true dollar amount and the impact that you're leaving behind.
Yeah, and then that just builds on this slide as well, right? Who is actually getting the money? Can they handle it? Right? You may need to have a trust in place, because what if, and Ken, I'll use your 500,000 number. What if that person inheriting that money is 18 years old? You love that 18-year-old child, grandchild, whatever it is. You love them, absolutely. Are 18-year-olds though typically the most responsible with that kind of money? Most likely not, right? So would you want to have it dispersed over a period of time maybe to them, right? The other thing, when you think about beneficiaries with new responsibilities, you may have that house that you grew up in and nobody wants it. What then? Right? Do you want to saddle it with, well, and Ken, I'll pick on you. Ken, it's your house now. You got to figure out what to do with it. Or have a conversation with the kids, and Ken says, no, I don't want that house. I have never wanted that house. I don't want to deal with it at all in any way, shape, or form. Okay, great. Let's leave it in the trust. And then the successor trustee has the responsibility of making sure the house gets sold. Right. So the reason I bring up successor trustees is, the attorneys we work with all say the same thing. Do not name a family member or a friend as your successor trustee. What does that mean? If you have a trust and you're married, you and your spouse are the trustees of the trust. When you two die, the successor trustee steps in and then makes sure the trust gets wrapped up the way it's supposed to. The challenge that most people end up with is they name a friend or a family member to be the successor trustee. Now that person has to go and wrap everything up. The challenge is that person is legally held to a fiduciary standard when they're doing it. And if they violate that fiduciary standard, they are now personally liable for damages. We had a client who recently got sued by a nephew for almost $300,000 because he tried to just handle it as the successor trustee. If you had named a bank, a trust company, an attorney, someone who knows the rules in the system to be the successor trustee, are they going to charge your estate money for that? You bet they are. Yeah, you bet they are. But they know the rules. They're not going to get sued. If they do get sued, they probably screwed up in a pretty big way, and there's other issues there. But it's not that, hey, I was trying to do something well intentioned, but it was totally violating this fiduciary standard. So when you think about who is going to be left behind, you've always got to be thinking about, can they handle it? Right? Can they handle it? From an update standpoint, so it's funny, this guy's been gone this long. This is Heath Ledger. And he's been gone for almost 15, 16 years now. It seems like he died just real recently, to me at any rate. For those of you who don't know him, he played the Joker in one of the Batman movies that he did really well with it. Well, when he died, he was worth about $20 million, and he left his estate to his mom and his sisters. So he left his 20 million to them. He had a $10 million life insurance policy where his daughter was named as the beneficiary of the life insurance policy, but his will had not been updated since before his daughter was born. Now, you can imagine some of the issues that potentially creates. The mom and the sisters didn't want his money. They felt like it should be the daughter's money. They turned around and gifted the 20 million to the daughter, creating a host of tax issues. So, children will be born, kids will grow up, they will have families, right? Spouses may come and go, right? Has your estate plan been updated to just keep up with your family? That's always something you got to be asking yourself, right? We hear, probably the biggest thing is, I want to make sure my daughter gets my money. If something happens to her, I want her kids to get the money, but I don't want her husband to get the money. We hear that all the time from people. Okay, that's something called per stirpes. You got to make sure that that is reflected in your documents. It's very simple. It's very simple, but just make sure you talk with your attorney about that. Okay, from an asset standpoint, in kids growing up, I know we've actually spent a fair amount of time talking about some of this stuff. Ken, do you want to just take a couple minutes when it comes to assets and co-titling with kids, especially some of the issues that can create?
Yeah, one of the biggest one that we see is, y'all are probably not surprised at all, but the divorce rate is higher than anybody expects it to be. No, rarely do people get married with the expectation or hope that, in 5, 10, even 40 years that a divorce is going to happen, which, by the way, silver divorces is the fastest growing sector in the divorce space. So it's happening. But when you leave assets behind, especially here in Texas and California, the community property states, that it's very easy for an attorney to claim that an inheritance is a commingled asset. Technically, an inheritance should be what's considered a separate asset, but any attorney with worth their weight in salt is likely able to claim that it's now commingled and now can be split with that new daughter or son-in-law in those instances. So through some very basic, very, very high level planning, we can make sure that your child has access to those dollars where they can use it within their marriage if they want, but in the instance of a death or divorce or something to that effect, that those assets will follow your wishes. And yes, you can dictate where it will still go to the daughter-in-law, son-in-law, or it follows to the next generation of your grandkids, anything that's deemed as your grandchildren. And that's probably the most common intentions we have with our clients building their estate plan. Because again, if it's just willed, If it's just in the will and it goes to your son or daughter and it's now a commingled asset, they get half. But if it goes into a trust where your son or daughter is the beneficiary of said trust, then it's fully protected. So these aren't the happiest of conversations to be thinking about, but minutes of work, putting it down on paper, you don't have to think about it again.
Yeah. Yeah. Okay. Divorce and remarriage. Divorce can create a host of issues for you in retirement. Yeah, you've got to rework everything, but it also creates some tax issues for you. As a filing single, which your marital status at the end of the year is how you file. So if you have to file single, you can see a bunch of issues from a tax standpoint, and issues that you might not even really be thinking about. Your Social Security, the rate at which your Social Security benefits are taxed could go through the roof. Your IRMA, which is your means testing for your Medicare benefits, that might go through the roof as a result, because now you don't have that married filing jointly umbrella that you're filing under. It's just your income is under your own. So you've got that issue, but was your will updated? Was your trust updated? Did you guys tear up the trust and write a new trust, which you might have to do? Do you still want, even though you got divorced, because maybe you just were sick of each other, but you still trusted that person's judgment, do you still want them to be the person that's making medical decisions for you once you've passed away? Or do you want that to be somebody else now? Right? So you've got all these different issues that come up. And yeah, kids, get married, they get divorced, whatever. But when you get divorced, that can create a host of issues, right? And so you're going to want to talk to an attorney, not just a divorce attorney, but you're going to want to talk to an estate planning attorney to say, hey, what do I need to update now that I got divorced? Tax laws, we can talk a little bit about tax laws. The biggest thing I'd say is that they are going to change. Okay. Tax laws are never constant. We talked at length a little bit today about how the Tax Cut and Jobs Act may expire at the end of 25. It may not. It may end up being renewed. We don't know yet. If it does, yeah, that's a huge change in the federal tax system. For those of you on the call who have a state income tax, your state income tax system changes too periodically. So you need to make sure that as you're looking at some of the estate tax issues, like Ken was talking about, step up in basis on non-qualified accounts. Does it make more sense to leave the non-qualified account to the kids and leave the IRA to the charity or the church or whatever, right? I mean, those are questions you should be asking yourself, right? Because what if the step up in basis rule were to go away? Well, now that changes your thinking, right? Because I don't know about you, but as much as I love being an American, I also don't want to have to pay more than my fair share of taxes just because I don't know the rules. So we need to make sure from a tax planning standpoint that your estate planning documents are also up to date as well. Last couple points, I'm going to kind of, yeah, this is a good spot. So what you're looking for typically is an estate plan that isn't just, hey, it's great today as of September 25th, 2024, but you're looking for something that's going to be able to be modified because your life is going to change. So a couple things we end up talking with people about quite a bit. One is something called jurisdictional shopping. Now, what a lot of people fail to appreciate is that there's a reason that companies choose typically Delaware to get incorporated in. And it's because Delaware has the best corporate protection law system of any state in the country. But if I look at, say, Microsoft as an example, their corporate headquarters is in Bellevue, Washington, but they're incorporated in Delaware. Why are they incorporated in Delaware? Best corporate protection laws, but the Delaware corporate protection laws apply everywhere. That's jurisdictional shopping. At some point, Microsoft's attorneys said, hey, we need to stop being registered in Washington. We need to go change our corporate charter so that we're now registered in Delaware. Here's the reason why. You can do the same thing. And when people say, oh, I can't do that. Yeah, you can. You could drive to, if you're in Texas, you could drive to Oklahoma and buy a car. If you're in Arizona, you could buy a car in California, New Mexico, Nevada, doesn't matter, and drive it home. It's still your car, right? You don't have to buy the car again just because you drove it home. Well, when you set up your estate plan, you should look at the different state systems that are out there as well. We've done a lot of that homework for people. The state that typically comes up as number one on the best asset protection estate planning is Nevada. Nevada has three big advantages over just about every other state. The first one is that it's one of the only states that's entirely digital in its system. You change your mind about where you want assets to go, you can log in, you can change your will, you can save it, it will date and timestamp when you saved it, and now you've just updated your documents. You didn't have to call your attorney. You didn't have to go see him. You didn't have to get new paperwork. You didn't have to then take it down to the courthouse and file it. You didn't have to do any of that. The second thing that Nevada does that no other state does, at least to my knowledge, is remember we talked about when they publish your will and they publish your stuff from a probate standpoint. Remember how we said that, yeah, legitimate businesses will come out of the woodwork to say, hey, can we help? But there's also maybe some shady people who will come out of the woodwork as well. Well, in Nevada, those shady people have to prove to a probate judge first that they have a claim against your estate before they can go after your estate. Your state doesn't have to defend that claim. They just have to go to a state judge, a probate judge in Nevada, and say, yep, I have a claim against Kenneth Hamilton's estate because I sold him his truck and he still owes me $40,000 on the truck. Okay, that's legitimate. Or maybe it's not, because maybe I really didn't loan Ken that $40,000 for his truck, right? That judge will make that determination. If the judge says, yeah, it's legitimate, go ahead and proceed, now your estate has to step in and defend it if it's going to. Okay, so that's a second huge advantage. And the third huge advantage is predictability, because like we said before, tax laws are going to change, probate laws are going to change. 10 years ago, no state had digital estate guidelines. Now, what do I mean by digital estate guidelines? What happens to your Facebook account? What happens to your Amazon login, your Google login, right? All that stuff. What happens to that stuff when you die? How does it get handled? 10, 15 years ago, no state had stuff in place. Now every state has something in place for that, right? Well, in Nevada, it's a negative consent state. What that means is that your attorney can just send out an email and say, hey, Ken, this recently changed in the state probate system. We're going to update your documents accordingly. Please contact me if you have any issues. And they don't charge you for it. Here in Texas, at any rate, because Texas doesn't have negative consent. That was just a double negative I used in that, by the way. But Texas doesn't have negative consent. Well, what happens is the attorney has to get a hold of you to make sure you know about the change, and then have you come in, make the change, charge you to make the change, the whole thing. If that attorney has 1,000 clients and there's a change that happens in this legislative session, and then in the next one, and then in the next one, and then in the next one, is that attorney ever going to get caught up? There's no way. There's no way they're going to get that caught up. So that's one of those things that you could potentially end up having to rewrite your whole estate plan and triple your expenses as a result. So jurisdictional shopping is something you need to take into consideration. Of course, we are not saying you have to write something in Nevada. We're just trying to make sure you know that that's an option. We do work very closely with a law firm called Integrated Trust Systems. They are based out of Nevada. If you want to learn more about that, feel free to talk with me or Ken or your financial planner, because we all work very closely with Integrated Trust Systems. But what do you do with all this information? It starts with an assessment. It's documenting what you have, taking some time to think about where you want those assets to go. We can help you through that process. And then if you even want us to help with the conversations, we're happy to have family meetings. We do that a lot for people. So let us know, but it all starts with that estate planning assessment. You can get a hold of us at, let me go back to usually our presentations have the contact information on the last slide too, but this one didn't. Okay. And just getting it reshared here. Ken, while I'm doing that, do you have any final thoughts?
Yep, I was sharing them, but I was on mute. Again, what's a
Oh,
Zoom call without doing that on mute?
there we go.
So I'm throwing it in the chat. If you enjoyed this conversation and you would like to share it or rewatch it, um, it'll take a couple of days, but we will get this through our compliance and get this uploaded to our YouTube page. So do subscribe, youtube.com/@Mission Financial Planners. And we have this. Matt gives a terrific weekly update. Last week was a huge week with the Fed cutting interest rates 50 bips. He talks about some of the positive and negatives of what that means for us and the economy. So check that out. We are going to be doing more of these workshops on a regular basis. We would love your input on what topics you would like covered, but subscribe. This is something great to listen to on your commute or on your walks, but also to share with your loved ones. So thank you for being here, spending your lunch with us. Truly appreciate. Again, there's so many people here, so thanks for being here. But in the link or in the chat is the link to our website, and then as you can see on the screen is our contact information. Matt, anything else?
I just want to throw a big shout out to George and Irma. They attended every workshop in this series. And we first met them in person at a Social Security workshop in August. So well done, guys. It's great that you've been taking part in all this. So thank you so much for your attention. And like Ken said, we're going to do a lot more stuff like this on a regular basis. Maybe not weekly, but certainly monthly. So but let us know, right? If there's a topic that's top of mind to you, let us know. We're happy to do a presentation on
And George and Irma, since you were here every time, we will be sending you a pop quiz that
it.
we are expecting great scores from.
Yeah, there you go. There you go. All right, great. Well, hey everyone, enjoy the rest of your week. Thank you so much for your time. We'll look forward to talking soon. And hey, make it a special day.
Adios.